Good morning, coffee drinkers. I'm Hallie Zobel with Private Corporate Counsel. I'm one of the attorneys in Orlando, Florida. We are here to serve you. I practice estate planning, guardianships, and trust drafting and probates. So every so often, we go to the auto mechanic and the car manufacturer tells us that we need a tune-up for our vehicle when it reaches certain mileage. In fact, I'm probably due on my Ford right now for a 60,000 mile checkup. And if there's no visual issues, there's a tendency not to go in and just let it ride as everything seems well, right? We do the same procrastination when it comes to our estate plan documents. I read somewhere that the actual time between when a person makes their estate plan documents or their last will and testament and then go back to the lawyer for amendments or changes is a total of 19 years. Wow, that's a long time. I submit to you, that's way too long to check things out. Recently, I had two brothers come into my law firm and hand me an assortment of documents they believed was their mother's estate plan. Well, it was a mess. The original trust was missing pages. The original last will and testament couldn't be found. There was no copy of the will to determine who was the guy in charge, and the trust had no assets titled in it. The potential clients were sent on their way to go find these documents and then come back to me so I could make a determination of what to do. Once I have every document in my hand and have reviewed them, I'm sure I can handle any of the issues that come up and guide them smoothly through the process. The mother had a revocable living will. That means she was the grantor and the trustee. The grantor is the guy who creates the trust, and the trustee is the person in charge of making financial decisions. This trust was executed in 2013, and I don't believe that lady ever looked at it again. The mother later purchased a piece of property, and that was not titled in the trust. Titling is the key to funding a trust. Funding the trust means you title assets into the name of the trust. If you don't take affirmative action to retitle the assets, then the assets won't go in the trust. What should be a time period to review these documents? I get asked that a lot by potential clients. Ask the clients if any family dynamics has changed. Has someone passed away? Was there a divorce in the family? Perhaps an adoption? Has someone been diagnosed with a serious illness? These are life events that could cause you to head back to the lawyer's office for amendments to your documents. At the least, do a review of your documents every 3 to 5 years, and you'll be in good shape. We can help. We assist business owners and individuals get their documents in order here at Private Corporate Counsel. We can be reached at 407-647-7887. My email is hzobel@pcc.law. Tune-ups for trust. This is today's law moment.